Senator Feinstein.
Thank you very much, Mr. Chairman. I would like to compliment the witness. You've been answering, I think, close to 15 hours worth of questions. And I know how difficult this is and hard it is. But I just want you to say that in this senator's eyes, you've handled it very, very well. So
Thank you, Senator.
And I'll move on to my questions. Congress has recognized how important it is for crime victims to participate in the legal process. And one example is the Crime Victims' Rights Act, which I authored with Senator John Kyle in 2004. That law provides certain rights for victims at critical stages of the legal process. The right to be notified, to be present, to be heard, among others. And I understand that in your 8 years as a district court judge, you would carefully consider victim impact statements when imposing criminal sentences. Could you tell us a little bit about this and how you considered crime victims in making your sentencing decisions as a judge?
Thank you, Senator. As you say, the law provides for victims to have an opportunity to address the judge, to address the court, to explain the harms that happen as a result of criminal behavior. And in the time that I was a trial judge, I found it to be a very important part of our criminal justice process because my sentencings were about handing down consequences for the behavior that defendants had engaged in and making sure that the defendants who received those consequences understood that they were getting those consequences because of the harm that they had caused. And so what I felt was important for promoting the purposes of punishment, which is what Congress has required of judges to do, is to ensure that the harms were made clear to the defendant in every case. So I had, for example, a case involving robbery. There were it was a single defendant who committed 2 robberies, one in April and one in September, of the same small pharmacy in DuPont Circle, which is not far from here. It's a small independent pharmacy selling pharmaceuticals, and this person decided that he was going to rob the pharmacy of their oxycodone and other kinds of prescription drugs for sale. That's a sort of standard scenario that we see in the federal system, but what was so particularly egregious in this case is that this defendant was so bold in his robberies. He came in April with a gun. He held the employees hostage, essentially, forcing them to open the safe with the drugs in it at gunpoint, stole the drugs. Not masked, not hiding his identity. And this is pre-COVID, so we're not talking about having to have a mask. He was a robber, plain and simple, with no fear of people identifying him. And then, in the period between April and September, he would come back to the pharmacy. He would loiter outside on the street. This is according to the victims. They would see him looking in the window. Once or twice, he came inside, looking like he was going to buy something and staring them down. And they knew who he was, and they called the police, and they weren't able to apprehend him because he hadn't really done anything at that point. And the people who worked in the pharmacy were terrified, and they were terrified by that behavior, the menacing nature of it. By the time we get to September, he actually comes in, and they think maybe this is another time when he's just loitering. But no, he pulls out a gun. He hops over the counter. He assaults one of the people who are working there and steals the drugs again. And that time they were able to call the police in enough time for them to come and apprehend him. So at his trial, he did not try. He didn't go to trial.
You're the judge.
I'm the judge. He pled guilty to this behavior, which was well documented. There was no defense that it wasn't him. But the guidelines in the case and the statutes that applied said because he used the gun, he was supposed to get something like 7 years. And I used the victim's statements to, first of all, explain to him how he had terrorized the people. Their statements said things. One woman said, I can't work at the pharmacy anymore because I am so fearful that this guy will come back. It's changed my whole life. It was a whole set of really horrible circumstances that I read to him at his sentencing so that he could understand what he'd actually done. And then I sentenced him above the requirement of the law because I thought it was warranted to make clear to him that this was a terrible, terrible thing that he had done to these people. So the victim's statements were really important because they explained to me and to him the consequences of his behavior, but beyond just how many drugs he stole or the fact that he used a gun. They were the real life circumstances that resulted from his behavior, and it was important for him to understand that.
I've listened to most all of this testimony, which I think now you've gone on for over 15 hours. And I just want to say that I think you have a stamina and a very good brain and a real sense of empathy has been communicated to me in these 15 hours. And I want you to know that. One of the things that I'm concerned about is that the public perception of the Supreme Court has turned increasingly negative over the last few years. A recent Pew Research survey found that 44% of adults have an unfavorable view of the Supreme Court. Less than 3 years ago, that number was 30% of adults that held that view. And I understand that as a judge on the D.C. bench, you have frequently accepted invitations to speak at public events in the hopes of giving the public more information about the judicial process and more confidence in the outcome. So here's the question. Why do you think there's been a decline in the public's perception of the court? And if you are confirmed, how would you strive to improve the public's confidence in the court and its decisions?
Thank you, Senator. I think that public confidence in the court is very important. It is, it's crucial to the rule of law that the public believe in the judicial process and therefore choose to accept the rulings of the courts, not just the Supreme Court, but all of the courts. It's part of the way our process works. And I think that I have taken that to mean, in terms of my role as a judge, that outreach to the public to explain what it is that we do, to inspire, hopefully, law school students and high school students, young lawyers in law firms and elsewhere, to think about careers in the judicial branch or think about careers in law as one of the ways that I have attempted to try to shore up public confidence. And if I'm confirmed, I would plan to continue as best as I can to do that kind of thing, because as you say, it's very important for the public to understand the work of the court and to follow its pronouncements concerning the law.
Earlier, when you and I spoke in my office, we discussed some of the people who have mentored you throughout your career. And one of those was Judge Patty Saris. You served as a law clerk for her on the Massachusetts District Court, I believe, early in your career. And you've spoken publicly about the role she has played as a mentor in your legal career. You have described her as, quote, a consensus builder, a good listener, a careful speaker, the essence of judicial temperament, end quote. So would you share with all of the members here more about how Judge Sarris's approach to judging and her mentorship have shaped you and your career? If you give some of the specifics,
yes.
I think everybody would be interested.
Thank you, Senator. As I reflect on her mentorship and also the mentorship of my other two judges, it's very interesting because I think I learned maybe different things from each of them. Judge Sarris, who was my first clerkship, you're correct. She's serves on the District Court of Massachusetts, which is the trial level court. I learned how to look at the facts in a case from Judge Sarris. That's part of what the trial court level does. We, as trial judges, develop the record in a case, take testimony, have trials, and she is extraordinary at developing a record and making sure that all of the relevant facts are adduced from the witnesses and considered in the context of her trial and record responsibilities. And so that, I think, is something that I learned from her in terms of the law, and her warmth and care for her law clerks meant that she has been a lifelong mentor to me. And ironically, she became the chair of the Sentencing Commission after I had been on the Sentencing Commission. So we worked together later in my career. So I often use that story to tell young people, you know, you never know what's going to happen. Someone who you worked for at some point might be your colleague down the line.
Well, let me just one more. You've handled a large number of cases during your career, both as an advocate and a judge. As an advocate, you've worked on a very wide variety of cases, from work for corporate clients during your time in private practice to your work for low-income clients during your service as a federal public defender. And during your 9 years as a federal judge, you've written nearly 600 opinions. I think that's really quite a sterling record. And I imagine that some of the cases have really stuck with you. And so I would like you, if you can, to talk a little bit about some of the cases, maybe one or two, that you've had that have made a deep impression and have really enabled you to progress as you have.
Thank you, Senator. Well, as you say, I have handled a lot of cases in my time, nearly decade on the bench, and you learn something in almost every case in some respect. If you're doing your job right and you're looking into all of the issues. I think there might be, I'd mention one from sort of a few years into my service as a trial judge. I handled a case, Yakai versus Napper. And the case involved trademark infringement. And you would ordinarily think that trademark infringement charges are dry and technical. And what I learned from this case is that even areas of the law that you might think apply only to businesses impact real people at times. So this case involved a small community, a cultural community of people who believe in vegan lifestyles. They call themselves the African Hebrew Israelites, but it's not a religious community. It's a cultural community around healthy living. And they have created a restaurant and a series of restaurants here in the Washington, D.C. area with menus involving really, I'm told, terrific vegan foods. And in this community, there was a member who was the one who created the recipes and who was responsible for the restaurant. The whole community had other aspects to it. He ended up falling out with the community, and the dispute involved his actions essentially taking over the restaurant and reopening it by himself using the same name. The restaurant was called Everlasting Life, which was a important phrase for this community. And he essentially ejected the other members because he was the leaseholder, or he had signed the lease on behalf of the community. And he kicked them out for a day, and then he reopened the restaurant using the same name. And so the question was, under the Lanham Act, which is the statute for trademark violations, the question is whether there is a potential for confusion in that sort of circumstance. But ordinarily, I see Senator Coons nodding. Ordinarily, when you have a trademark infringement, you're talking about two different businesses who have very similar products. And the question is, are they similar enough to cause confusion? Because the idea of the law is that people should be able to have products that are identified with them, and you shouldn't be confused. And in this case, we had a bench trial about it, but it was pretty clear. I was the fact finder as the judge. It was pretty clear that when you open the same business with the same name, using the same recipes and food, that you have created this kind of problem that is a trademark violation. But what was so interesting to me about the case, in addition to the fact that I got to be the fact finder, it was a bench trial, was that we had witnesses come in who testified about the circumstances. This was a very small community, and they all knew each other, and the testimony about what it meant to them to have one of their members ejected in this way and then have him turn on them was very, very moving in the courtroom. So even though we were talking about this kind of arcane area of the law, it was real circumstances that were happening.
Well, stop for a minute.
Yes.
I think you're a very important addition to the court. And what I'm trying to fathom out from the hearing is, what kind of judge will she be? How will we look at her in 5 or 6 years? And so what I really want to ascertain is what kind of a judge you will be. What will be the principles you hold dear, and how will you function in this capacity? If you could just answer that one question. I've been waiting for it for about 15 hours, so I'd appreciate it. Thank you.
Well, I would hope to be the kind of judge that I have been during this last decade. I have been the kind of judge who understands that it's my responsibility to rule neutrally, to not have any agenda when I'm looking at a case. I've been the kind of judge who understands that facts matter, facts like the ones that I was just describing, and that it's important for a judge to take into account and be able to understand the arguments of all of the different parties and participants. And I've been the kind of judge who takes my responsibility to not be a policymaker, to try to understand and ascertain the will of Congress if it's a statute, or to hew to my own, I've been saying, stay in my lane, to not exert my authority beyond what the Constitution requires when I'm interpreting and applying the law. I think I've been the kind of judge who lives up to the oath in terms of being fair and impartial, ruling without fear or favor, and ruling consistent with Article 3.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Feinstein. Senator Cornyn?